Yeah, I welcome all of you here for the continuation of the session 4 from the morning. So before we begin the session officially, there are a few instructions that I want to give it to all the delegates and the observers. I kindly request all of you to keep your microphone off for the entirety of the session. Uh, I request as and when you are presenting, unmute yourself and kindly put forward your presentation and your queries and questions. For the other times, I kindly request all of you to have your microphone off so that we can continue our session without any issues. I also will request all of you to have your videos on at all the times. It is again a kind request. If that is not possible, that is still fine. We would at least will require you to have your video on while you're making your presentations. We do also understand that some of you might not be in the position to do that. That is acceptable, but the request is to, while you're presenting, kindly try and keep your video on. And for all the delegates who will be making their presentations, I request all of you to stick strictly to the time limit given to you in the guidelines, which will be between 5 to 7 minutes. So we have Mr. Vinudeep with us, a final year student who will be the rapporteur for the event. And we also have, do we have Gokul Abhimanyu with us already, Vinudeep?
I am not sure, sir. I'll.
All right. He should be joining shortly. So
Yes.
we will have Mr. Gokul Abhimanyu, another student. He will be keeping the time, and you will be receiving notifications from him as and when the remaining time that is left. But once again, we request all of you to stick to the time limits so that everybody's presentations are made on time. Any questions and queries is not allowed during the presentation. So when a speaker is presenting, kindly do not unmute yourself and interrupt the speaker, because that will cut the flow of the speaker. So that is not strictly allowed. But by all means, you can put out your questions and queries in the chat box. So when a speaker is presenting and you have any questions to the speaker, kindly type it out in the chat box, and with the permission of the chairperson, your questions can be answered duly. Or else at the end of the session, after all presentations are being made, there will be a time given for your questions. At that point in time, you can unmute and put forward your questions. So to repeat, the kind request is, do not unmute yourself and cross the presenter as he or she is making the presentations. That's again a kind request. Uh,
Can,
so
can I make a
yes,
small, in the last session, I didn't see the question. I didn't check the chat box so much. Were there a lot of questions?
I was not there, but what
No.
I will do is that in case if there are questions that goes unnoticed, I will bring the attention of the chairperson and the others by reading it out to the entire
Yeah,
panelists and
that
delegates.
might
Will that do?
yeah, thank you.
Yeah.
Also,
Thank you.
none.
Thank you.
There weren't any questions last session. So.
All right. All right. On that note, one kind request to all the participants and delegates is that if you have a question, kindly do put out to everyone. There is an option in your chat box which allows you to ask to specific speakers, and there is another option that lets you ask a question to everyone. So kindly put out the question to everyone so that it doesn't goes unnoticed. And while answers are given, others will also be able to understand what question is being answered. So kind request is that please do not direct it to the speaker, direct it to everyone, so that if it goes unnoticed by the speaker, we can put it out loud and get answers for the same. And one more small notice: if there are few of you unmuted during the presentations, I will take note of it, and I will take the duty to mute you. All right. So kindly do not do so, as I already requested. While a participant is presenting, please do not unmute yourself and interrupt. So those are the information and guidelines that I have to give to you. Are there any questions? If not, we shall go and proceed. Or all the delegates fine with that?
I have another, point. Nidish, is it okay? Like I did it in the last session, I was signing up and giving a short comment in the presentation before asking the next presenter to present his or
Uh,
her. Was that all right? Do I follow the same
yes,
format?
Yes, Chairperson, absolutely all right. From now onward, the stage is yours. You can decide as and when how you have to run the session. So it
All
is
right.
all up to you and your choice. Yeah, just one final word. All the delegates who will be presenting the paper, kindly send your name along with your institution's name as a chat message, either to the group or to me. You can find me. I'm Nidish Kumar on the chat box for attendance purposes. So this is again a kind request. I request all of you to type in your name along with your institution's name. If you are two speakers, put both of your names and your institution's names respectively and send it either to me or to everyone so that your attendance shall be duly noted. Uh, so yeah, those are the instructions. I hope everybody are clear with what we'll be doing. With the permission of Honorable Chairperson, shall we go ahead and commence the event?
Thank you very much, Nidish. Let us begin. I welcome everybody for the 4B session in
Ma'am,
yeah,
Uh, sorry to interrupt you. There are few people who might be joining new for session. Would you like me to introduce you to the gathering?
please, if you, yeah.
Yeah, yeah. Thank you, ma'am. So I once again formally invite all of you, and uh, Dr. Anandita Mukhopadhyay will be the chairperson for this session. I welcome you once again, ma'am. Uh, Great honor and pleasure having you here. Madam is a professor at a Department of History in the University of Hyderabad. Uh, Ma'am has got a doctorate from School of Oriental and African Studies, present in London, United Kingdom. Uh, Her specialty is in modern Indian history, and ma'am have received many academic accolades, including fellowship from Indian Institute of Advanced Studies, Shimla, and also a Commonwealth scholarship. Uh, the cultural identity and the cultural history of colonial India are few amongst the many research interests that ma'am possesses. Further, ma'am has numerous amount of academic works, including book publications, book chapters, research articles to her name. It's an honor to have such an educated intellectual person here amongst us to chair this particular event. And I welcome you once again, ma'am. From here on, the stage is yours. You can run the session. Thank you, ma'am, and welcome once again.
Thank you, Nidish. I will not put the video on because my connection is a little unstable, but
No issues.
just for the first few minutes, I'll keep it on. Then once people get used to my mug, I will, switch it off.
All
Thank
right.
you very much for that very generous introduction, and I welcome everybody to this particular session. This is legal history, a very, very badly researched area which needs special attention from everybody. And I would like to make a few comments before I ask people to present their papers. First of all, uh, uh, legal history is also a history of ideas, and it is very exciting to be able to see how a different legal culture came to India. We also need to, as Dr. Santosh Abraham talked of in the morning, this was also the first very important switch to a documentary or a written way of understanding a judicial process, which generated a huge amount of records. And we became a documentary or a paper culture, right? And that was an extremely important modern transition for all of us. We also need to understand our present day locations within a certain understanding or a framing of the rule of law, which is, I think, very important to demystify, because law is not about, I think, force or coercion. It is much more about a larger culture, a larger legal culture, which we need to incorporate into our civil lives. With these few comments, I invite the first speaker, Dr. A. Adaykalam, Assistant Professor, Department of History, Thiruvallur College, Papanasam, Tirunelveli. He is going to speak about public health in British India, a brief account of the history of medical services and disease prevention in colonial India. So over to you, Dr. Adekalam. Please unmute yourself. You're not being heard. Please unmute yourself.
Do we have Mr. Adekalam with us? Can you let us know your name that you have entered in the registration box?
Hello, Dr. A. Adekalam. Okay, we will pass on to the next speaker, and we will keep the slot open for Adekalam at a later stage. Okay, this is Dr. Hemlata Bhatt, Assistant Professor of Sociology at Tamil Nadu University, Tiruchirappalli, a sociological discourse of territory and citizenship in French India or Pondicherry, a fascinating topic. Please, Ms. Hemlata.
Thank you, Professor Mukhopadhyay. I hope I'm audible to everybody. Am I audible? Am I clear to everybody?
Yes, you are.
Thank you, Professor. Thank you, Chair, and thank you, my colleague, Mr. Nidish Kumar, and my dear student, Mr. Vinudeep, who is helping me with this presentation, because I stay in Tanjavur, and because of rains, there's some kind of disruption that's happening in the bandwidth. So that's the reason that I've asked him to, kind of help me out and, kind of putting the PowerPoint presentation there. So, so I understand that I have 5 to 7 minutes, and I'll just, for the sake of more clarity, I will just stop my video, and once the presentation is done, I'll again, kind of switch on my video. I hope that's fine for everybody. So I'll try my best to, convey the main things within this given time. Of course, I apologize if I have left something out. So now I'll straight away get into the presentation. And the thing is, the first slide itself says about the sociological discourse of territory and citizenship in French India of Pondicherry. Usually, the discussions on territory, territoriality, and citizenship is basically restricted to political science and history. But there is a way to look at these concepts sociologically, and that's what I have attempted in this particular paper. And when it comes to French India and the English India or the British India, there is a huge difference the way the two empires have, colonized this country. And when it comes to Pondicherry or the French colonies in Indian territory, basically in the second slide, you have the 5, places which the French kind of initially, when they had come to Pondicherry to trade or India to trade, they had Pondicherry, Karaikal, Mahe, Yanam, and Chandanagar, which they had called as lodges, meaning, and also Surat was also part of it, but of course they left Surat at least 150 years ago. So these are the places which they chose for actually doing their trade. And like how the British had their British East India Company, the French did have their own East India Company, and they had come with the purpose of trade. But what happened eventually, and how today, whenever we talk about Pondicherry, I'm sure many of you, when you walk through the streets of Pondicherry, you still see the French reminiscence there. Even the streets are called as Rue, and you still have the French names everywhere. Children are named, are given the French name, so on and so forth. And people do speak, language. The Tamil language itself has, some of the French words that you get to hear. And all this is because of a unique process, which they call it as Crayola. And sociologically, if you analyze it, it is nothing but a process of assimilation and acculturation, which is what we are going to see in this paper. So if you take to the third slide, it's not that Pondicherry was something that got to be known
Hello.
Hello, you're not audible. Hello, you're not audible. Dr.
Very
Hemlata,
important, having the it as
Hemalata ma'am, are we audible to you?
yeah.
Ma'am, we had a network issue
Yes,
for the past
audible to
30
you?
few seconds. Yeah,
Okay.
now you are audible.
Yeah.
Yeah.
So now am I audible? So it's like I just started saying that it's a Pondicherry is not something that we know only from the French occupation there, but we know about Pondicherry because you have a very ancient site of archaeological importance called Arikamedu, and that's where you get to know about Pondicherry, where the Romans had traded as early as 2nd and 3rd century AD. And even before the Dutch arrived there, we had even before the French arrived, we had the Dutch who called it Pulucherry, the French called it Puducherry, and the English called it Pondicherry. And that's why, the state of Pondicherry, or the Union Territory of, of Pondicherry in the year 2006, again went back to the old French way of addressing itself, that is Puducherry. So you now write Puducherry, and Pondicherry is what the English had actually, kind of referred to. Now, coming back to the fourth slide, or I mean, this is where I thought this is how I have compartmentalized my paper. Although I'll not be able to discuss everything that I have given, but I'll try to majorly touch upon the few things that are of some interest to us and which I thought I should share. Now, whenever we talk about the nation state formation and discourse of territory and citizenship, I would just like to briefly go to the next slide and come back to the same slide, where we are talking about these are the things that we have experienced in our country, meaning the referendum, annexation, secession, and cession. So when you talk about referendum was a mode that in the year 1956 and 62. I mean, the de jure transfer was in 1962 that officially Pondicherry merged with the Indian Union. And so that's where, through the process of referendum that we got merged with, the Union of India. Now, going back to that previous slide, when we are talking about the first phase of development from 1672 to 1761, which I would call the premium rencontre of Pondicherry, of the French in Pondicherry, it is quite interesting to note. I would request you to, kind of go to the 5th or 6th slide, which, now this is the first phase of development where we understand that with the governor, the French governor Francois Martin, in fact, he was the virtual builder of Pondicherry in many ways. Why is he called the virtual builder of Pondicherry? Is because Pondicherry, as what we think, is not a small enclave that the French just like that got to occupy. It was something, a purchase of different villages from the Arcot of Nawab. And I'm sorry, the table is so small, I don't think it is visible. But in 1701 and 1706, 1715, 1713, so on and so forth, we the governor of Pondicherry actually literally got these villages from the the Nawab, purchased this, and that's how Pondicherry was built during his time, which is between 1699 to 1702. This is one thing, of course, that we get to know about Pondicherry, the French in India. But what is more important is the Dubashi culture, and which eventually led to this process called Crayola, and that's what is the main crux of our paper. Because whenever we are comparing the British India with the French India, the British India, we get to hear this discourse on who is an extremist and who is a moderate. There is no concept of Crayola. There's no concept of citizenship being extended to the people who have been colonized by the British. But it's not the same case when you talk about Pondicherry. When you're talking about Pondicherry, Pondicherry still does not have that kind of animosity towards people who have been in the extreme spectrum of voicing for independence. It does not have that kind of the same animosity that the British India did have towards its people who demanded freedom. Secondly, you also do not have the same the kind of administrative division. In fact, even today you go to Pondicherry, you have only the commune system of administration. That is sorry, am I audible? Sorry, briefly it just got cut, I guess. So you still have the the commune system. The every administrative division is called as a commune, and that's what we kind of inherit from this 158 years rule of the French. And so the Dubashi culture, meaning basically the Dubashis were people who were brought by the French governors, and they were employed. They were actually the company's employees, meaning who had actually had knowledge of different languages. Dubashi, it's actually Dvibashi, which became Dubash. So Francois Martin, who actually brought Nayana Pillai, a merchant from Perambur, which is of today's Madras Presidency, I mean the then Madras Presidency, and today a suburb near Chennai, who was the first one to come and help the French merchants in trade. And there were mainly three castes who had actually, were the first Dubashis, the Mudalias, the Chettis, and the Pillais, who basically, kind of became the Dubashs of Pondicherry. And the second discourse that so interesting about Pondicherry is that historian Matheson Mines writes about the left and the right hand caste division. And Pondicherry did have this thing, and all the merchant castes, that is the Mudalias, the Chettis, and the Pillais, were the left hand caste division, and the landowning caste belonged to the the right hand caste division. And so I would just request Vinudeep to go to the next slide. And what is so different between the French and the British is that in Pondicherry also we did have caste clashes, but the French were a little different in handling the same. In fact, in 1717 they broke a huge riot between the right hand and the left hand caste division. And this was an incident which changed the entire course of of the idea of citizenship, because in 1881 the French introduced a process which is so unique when it comes to the French French colonies, which is called as Renaissance, and which means it gave the option to the natives to renounce their native personal law and adopt the French civil code. That means they become the French citizens by adopting this process called Renaissance. And it is very surprising, and in fact it is something that is very noticeable, that in 16 by the end of 19th century itself, we did have a huge population of Renaissance. And between 1881 and 1882 itself, you see 4,402 Renaissanceos. And in this, we observe a trend, that is the first people who opted for this process were from the depressed caste, because they just wanted to escape the disabilities of casteism. And then you also found that the people who became the Dubashis, that is people mainly from the three castes of the Mudaliars, Chettis, and the Pillais, also did kind of adopt this process of Renaissance. And that is the reason that even today you see a lot of French pensioners in Pondicherry. People generally think that French pensioners are people who just work in the army of the French, and that's why they get the pension. No, but they are the descendants, they are the children of these Renaissanceos who either continue to live in Pondicherry or who are in France. So this is one different approach that the French had when it came to kind of handling the caste clashes and the caste rift that was there in the Pondicherry. And the second thing is that what you notice, like unlike the unlike the British India, the French started establishing schools as early as 1827, and you had two major schools, one in Pondicherry and the other in the Caracal, which actually gave a very good opportunity for people, especially from the depressed caste, to kind of opt for the process of Renaissance, because they knew what exactly was the benefit of this. Going to the next slide, I would like to just touch upon this process of Crayola. Now, whenever we hear this concept of Crayola, it was first used in the 16th century to identify the descendants of French, Spanish, and Portuguese settlers in West Indies. And the meaning, I mean, the term did not have a nice meaning at the beginning, meaning it was just a slave born in a master's household. But today, you see, it's no more a term with a negative connotation, because you go to any number of French colonies, be it Guadeloupe, be it Reunion Island, and even Pondicherry. Creole is something which signifies a sociological process of assimilation and acculturation process, and people do not take it in a negative sense. And this French Creole is something so unique to Pondicherry that there was no discontent created by the French towards the Indian patriots, and that is one of the outcomes of Creole process that we get to kind of observe in Pondicherry. Although the number of representatives as early as 1950s itself chose to merge with India, the whole process was in such a manner that it did not create any discontent, it did not create contempt, it did not create animosity, unlike what you experienced in 1947 during Indian independence. So this is something that sociologically one gets to see. And so the entire discourse of citizenship and territoriality, when it comes to the French in India, you still have a section of population who are French by their citizenship, but who think that their roots are very much in their land of India, and they kind of give equal importance, or their identity is something that they hold it so dear that they consider themselves to be from both the lands. And I would just I know that time is up, so I would just like you to just go through the other slides. I would just take a minute more, not more than that. So you have, this is how Pondicherry looked in 1761, a small lodge, and then you have a map that is available as early as 1706. These are the French, streets, the court building of the French India. Next, then of course these are the old pictures that I got from the archives, so I thought I should be sharing. So on the 24th October in 1954, we had the de facto transfer, and you see this is where the whole thing of among the 178 councillors, 7 voted in favor of French rule, but 170 voted to join the Indian Union. And so you will just see how this whole period polling booth, which was in 1954, which is the de facto transfer day, happened. And so these are the images that I thought I could share with you, which indicates the referendum. And so some of the councillors at that point of time, the prominent people who were behind this entire referendum. And this is the ballot paper. You had 2 languages. One was in Tamil, the other in French. So oui and non. So you had to kind of vote. And so this is Pierre Landi and Keval Singh. Keval Singh was a Indian Consul General appointed for this specific purpose until the de facto merger. So we have the 2 consul generals sharing the agreement. And then here you have Jean-Paul Gamier, who was the ambassador of France. And 1962, we had the de jure transfer happening. And so this is again Keval Singh, after the de jure transfer, taking the salute along with the government of government formed at that time under Purushottama Reddyar. And so I think briefly I have just shared with you what my thoughts are. Thank you for this opportunity. Thank you, everybody.
Thank you, Dr. Hemlata. That was a very, very sharp paper, and I do have a couple of comments. It is a very important connection that you have drawn between a bestowed citizenship by virtue of residence, by virtue of residential status. And I would also like to kind of ask you, Aurobindo Ghosh had been part of the Pondicherry territorial sanctity as part of the French territory after 1911. He avail himself of renunciation, or how do you pronounce it?
Renaissance.
Yeah, Renaissance.
No,
Yeah.
he was not a Renaissance. In fact, Pondicherry had, introduced a French passport system in the year 1798. And when Sri Aurobindo arrived in the year 1910 in Pondicherry, he straight went to one Shankaran Chetty house, which is still there. And that time, the law of Pondicherry was that 5 prominent people will have to sign, a character that certify his character and give it to the French government, that his character is certified, and he being in the soil of on the soil of Pondicherry will not be a problem. And so there were 5 people who did sign for him, and that's how he got on to stay. Although the British had already passed on the information to the French that an extremist and who is most wanted by the British has come to the French soil, since the French had got these 5 people's attestation for Sri Aurobindo, they did not kind of pursue the matter further. But we do know that for a few months after he arrived in Pondicherry, there were intelligence officials who were kind of keeping a track of him. But later, because he announced that he is not going to involve himself politically, the whole thing got dropped off, and eventually he went on to establish the ashram that you find today. Yeah, so that's the answer.
Thank you. Thank you very much. Okay, that was really very nice. Now we go over to the next set of speakers, Vindeep R. and Ashwin Bala Someshwar. They are senior advocates. They're going to talk about senior advocates, history and relevance of the elite class of advocates. Please, Vinudeep and Ashwin, please make your presentation.
Thank you, Professor, and members of the panel. I will be presenting my paper on the topic Senior Advocates, History and Relevance of the Elite Class of Advocates. And I wrote this paper along with my friend, Ashwin Bala Someshwarar. But I would be presenting this paper on my own today, and my friend is also there in the panel. I have 1 minute. So I've structured this paper in the way that I've presented before you in the PPT. The first part of my paper deals with the classification of the legal profession in England, which the relevance of this is that the legal profession as we see it today in India is an inheritance that our colonial administrators left for us, and the judicial system that we follow today is an inheritance that we or rather a legend that they left us when they left India. And the second part of it is how the colonial administrators saw legal profession, how the classification of legal profession happened in British India. And in this particular topic also, we need to see 2 timelines. One timeline is before the Victorian letters patent, which established high courts at presidency towns, and after the establishment of presidency town courts, high courts, the difference, there is a lot of difference in the legal profession and the classification of the legal profession. So those will be 2 timelines in colonial India. And we come to independent India, the passage of the Advocates Act of 1961 and how it classifies advocates, and the relevance of such classification in today's world would also be discussed. So the origin of legal profession and the classification in Britain. This goes back to the Norman era. Though our session starts from 1700, I am forced to go back to the 13th century, around the years 1270 and 1303, when immediate, or rather even the 11th century, when the Norman conquests actually happened. So Anglo-Saxon laws were followed by the natives of the people living there and the descendants of the Vikings living in Great Britain. When the Norman conquest happened, there there came to be a lot of French influence in English law, and uh, the elite class of people were people from the Duchy of Normandy who were basically French, and therefore there were a lot of French usage in administration and the upper class of the society. Therefore, naturally, we have the laws coming with a hint of French touch. Now, that being that, what happens is after the Normans came in, we have the court systems springing up. Even though there were courts before in the Anglo-Saxon times itself, we do not see a distinct legal profession that was created. So, in the beginning of the 12th and 13th centuries, what we see is we see litigants being assisted by their friends. They bring their friends to court, and their friends assist them in pleading, the oral pleadings as well as written pleadings, and they say the formal words that need to be said before a court of law to uh, make a pleading, or make a submission, or even ask for a relief. Now, these pleaders, they became two distinct class of professional legal, uh, say, assistants, or rather people who assisted litigants with their litigation before courts of law. First they were non-professionals, and in the beginning of the 13th century they become professionals. And the first type of professionals that came into being were pleaders, or they were called narrators. These narrators pled their clients' cause before the court of law, and at times they also pled questions of law before the courts of law. Now, as this is going on, as the pleaders have developed, there came another uh, class of advocates during the time of uh, uh, during the beginning of the 14th century. We see the entry of a new class of advocates called attorneys. These attorneys do not do oral pleadings, but in the beginning they have the job of only the written pleadings, and they draft written pleadings for the court. And there is a disparity between the class of pleaders and attorneys right from the beginning itself, and we would see the significance of this when we come to the distinction between barristers and solicitors. Now, the pleaders, what pleaders did, as I told earlier, or narrators, was to plead the case before court. Now, during the rule of King Edward VI, we see that the king appoints a servant of law to represent his cause, or the crown's cause, before courts of law. And this servant of law is they are come to known as servants or sergeants at law. In the beginning, servants and sergeants at law are appointed by the crown itself, and later there is something that, I'm sorry, did someone want me to stop?
Yes, just a second. Mr. Abhishek, can you mute yourself? I am unable to mute you if you are not. Yeah. Thank you. Continue.
Thank you, sir. So, what these servants of law do, they take forward the cause of the crown before the courts. Now, these servants come from a set, something called the inns. Now, in the 13th century, towards the end of 13th century, the Pope stops or prohibits the clergy from teaching common law in schools of law, and many clerical, that is schools of law run by clergy, is shut down due to the prohibition of the crown also. So what happens is several sergeants come together, they form something called inns of law, which is basically hostels for students who want to pursue law. They create those hostels, they teach classes, and that is where barristers come in. These inns of law are called inns of chancery and inns of court, and these inns of court become inns of bar, and whoever becomes a member of these inns of bar, they are called as barristers. And these barristers are again classified into inner barristers and outer barristers. inner barristers are the students, and the outer barristers are senior students who may represent case on their own without the help of a sergeant or a senior member of uh, the inn of the courts. Now, this barristery comes at a very high cost. There is an estimate that for today's inflation, uh, there is an author who said that at that point of time in the 1400s, it cost around 19 pounds and certain pences for a person to join these courts, inns of court, to study law and become a barrister. That if we adjust it for inflation today, it comes to around 22,500 pounds, which is a very, very huge amount to study law. And this created a very big disparity in status of people becoming barristers, because only nobility and children of nobility who were future nobles could afford to go to these inns of courts. Therefore, if someone wanted to practice law, they had to become an attorney. And for even for attorneys, there were exams towards the 14th and 15th centuries. Now in the 16th century, what happens is attorneys are allowed to go to the inns of court, but at a very small point of only for a very small point of time. And later in the 17th century, they are completely banned from becoming members of the inns of court unless and until they are qualified to become. Now, towards the 17th century, there is another class of advocates that is created by the crown itself again. And this is because during the Tudor period, sergeants were appointed left, right, and center by the crown, and they lost the value. Once people who were appointed to the bench directly from the order of sergeants now became very, very, say, normal because of the Tudor intrusion in the appointment of sergeants. Therefore, the king and queen's council, as the case may be, if the crown is belonging to a king, it would be king's council. If the crown belongs to a queen, it would be queen's council. So these kings and queens attorneys go on to represent the crown now, and they're in the beginning of the 17th century, they are paid a certain amount of money as for retention of services annually. Now, later on, this retention of services and the payment in due course is stopped. And towards the 1920s, the requirement of them having to request the permission of the crown to oppose the crown in a court of law also is taken. So they become normal attorneys like our senior advocates today. So kings or queen's council is someone who's taken the silk, is something like a senior advocate that we see in our profession today. Now, coming to attorneys, as I said earlier, attorneys were people who were only uh, people who drafted uh, written pleadings, and therefore they did not go and plead before the court except for a small window in the 15th and 16th century. And towards the 19th century, attorneys were completely abolished and all the attorneys were deemed to be solicitors. And today we see solicitors doing the job of primary attorneys. Now I move on to India. I travel along with the colonizers to India, and I come to the classification of legal profession in India before 1862. There is an establishment of mayor's courts in the presidency towns. The Regulating Act of 1773 establishes Supreme Courts at presidency towns. Now, establishment of courts is one thing, and the Regulating Acts also establish or give legitimacy to the Sadar Adalats, the Diwani Adalat, which is the civil court, or and the Fauzdari Adalat, which is the criminal court. And these courts have to have people to practice in. So in the Supreme Courts in presidency towns of Madras, at Fort St. William and Bombay, we see only British attorneys and British barristers are allowed to practice. By British, I mean people from England, Scotland, and Ireland. So only people of that nationality are allowed to practice as barristers and attorneys, and all other native practitioners called pleaders, vakils, muktars, or revenue agents, all of these people are allowed to practice only at Sadar Adalats or Mofficial Adalats. And we see this even in the regulation 10 of 1802 of Madras, regulation 10 of 1818 in Bengal also. Now, that being said, we have the first war of independence in 1857 and the change of the mode of governance in 1858 with the introduction of the Government of India Act 1858. And in 1862, Queen Victoria issues a letter patent to establish high courts of judicature at Madras, Bombay, and Calcutta in place of Supreme Courts. And there is a formalization of judicial procedure by the abolition of the Sadar Adalats and the Diwani and Fauzdari Adalats, a complete anglicization of the legal profession and the judicial system is made. Now, barristers, attorneys, vakils, muktars, and revenue agents are the classes of legal profession in this time period that we are talking about. And around 1886, Madras High Court allows vakils, that is, native pleaders, to argue before high courts. And you guessed
Mr.
it.
Vinadeep,
Yes, sir.
I hope you are not seeing your chat box. There has been multiple notifications that your time's up. Kindly try and wrap it at the earliest. All right, just a kind notification.
Yes, sir. I'll just take 1 minute and wrap it up.
Yeah, thank you.
So yes, the native pleaders are let into the high courts, and which is obviously challenged by the barristers who say we are not allowed to practice in the lower courts. Why are they allowed to practice in the high courts? There is a disparity between native and European advocates at this point of time. Now, in 1961, we see the introduction of the Advocates Act, which under Section 16 classifies two classes of advocates: senior advocates and other advocates. And this classification is challenged in Indra Jaising versus Supreme Court of India, for which the judgment was passed in 2017, where the court held it is not an unreasonable classification, but there were certain guidelines issued. Even after guidelines were issued, there are certain discrepancies which I've put down in my paper, taking into account various high courts rules in designation of senior advocates, the main of which is the overlooking of trial advocates. All of these courts say that practice before a high court is necessary for designation as a high court as a senior advocate. But this is an arbitrary rule which creates a class rift between trial court advocates and advocates who practice exclusively in trial court and advocates who do not practice exclusively in trial courts, which is not a classification foreseen by the Advocates Act, and therefore is against the scheme of Article 14 of the Constitution of India, which looks for equality and equal protection of law. Now, this particular classification and the trial court and non-trial court advocates classification, which is arbitrary, can be seen in comparison with the barrister attorney class divide in England and the barrister vakil native European or native imperial colonizer divide that is seen in independent India. So the question today that is posed before this forum is whether this particular disparity is necessary, even when a senior most person of this profession, like Mr. Falias Nariman, recently uh, uh, opined that this particular provision of law is unconstitutional. Thank you. I thank the university and everyone for this opportunity and a patient hearing.
You know, Dr. Vinudeep, I had actually read your article last evening and I found it really fascinating. You have actually done two processes here. One, you have traced the coming of a very sharp class wedge in Britain, driven between barristers and solicitors, attorneys, basically. And then you have looked at the way in which this inequitable system is imported into the Indian frame and the consequences, even in post independence India. It was fascinating. I enjoyed your paper very much. Really a very, very nice paper indeed. Thank you very much. Okay.
Thank you very much, Professor.
So we will go.
Professor,
Yes.
may I? So Dr. Adekalam, who was supposed to be the first speaker, is have joined us. So I leave it to your decision to when to call upon him.
Yes.
Thank you.
Of course. Yes. Thank you for telling me. Right. Dr. A. Adekalam, please, Assistant Professor, Department of History, Tiruvalluvar College, Papanasam, Tirunelveli. He's going to speak on public health in British India, a brief account of the history of medical services and disease prevention in colonial India. We are looking forward to your presentation, sir. Please present.
Good evening to everyone. My topic, public health in British India, a brief account of the history of medical service and the disease preventions in colonial India. The aims of this paper to highlight a public health in British India and the history of disease prevention in that part of world in the 19th and early 20th century. That provides a valuable insight into the period that witnessed the development of new trends in medical systems and a tradition from service to microscope studies in medicines. It harbours the earliest laboratory work and groundbreaking achievements in microbiology and immunology. The advent of influenza disease and trophic medicines was a direct consequence of pollination. The history of disease and their prevention in the colonial, the conductors back the embryology of influence disease, many of which are still prevalent in third world countries. It relieves the development of surveillance systems and the response to epidemics by the imperial government. It the debaters cover the establishment of health system under the colonial power, saved disease control in British into the improve the health of its citizens. The establishment of medical service. The history of the Western medicines in India dates back of 1600 when the first medical abuse arrived in India along with the British East Indian Company. First built a ship structure in 1757 in the East Indian Company established its rule in India, which helped to the development of civil and military service. A medical department was established in Bengal as for back as 1764 for reading the medical service to the troops and servants of the company. At that time, it in the medical department we established a Bengal as a back as 1764 for the reading medical service to the troops and servants of the company. At the time, it the consider of 4 head strength, 8 adjacent structure and 28 structures meters in 1775 hospital sports were found too. Administered the European hospitalist comparing of the Surgeon General and Physician General. The uh, the disease, the control and preventions. When the British Emperor come into power in India, they faced the challenge of a new set of diseases that were endemic in the region. India was a West country with enrollment reigning for the world's highest mounts to plant region field. And from the tropical, the forest, foreign threats, uh, such as division, the region had its own peculiar disease with were difficult to prevent with the limited resource of the IMS. In enormous amounts of work were done of the prevalence of evidence to save the life of people in India in general and the imperial troops and officers in particularly the epidemic disease that the division's effects during that breed were blocked. Liberally, the plague, the leprosy, the cholera, and malaria. The British government took great effort to prevent the disease, but through the insufficient medical officers and funds. The major trade was to allowed successful and rendered service as it was slowly a strength responsibility during during that period with the virtually now volunteers of private organization. The provisions and the environment legislation and how long being regulated in was into 19th century had we government released that many deaths would be provided and public health service were strengthened. Thank you, madam. Thank you, sir.
Thank you, Dr. Aday Kalam.
Thank you.
It was a very nice, very sharp paper, but I just wanted you to reflect a little upon, I think the first time, a first time in Indian governance that a legal structure, a legal framework is hooked, is attached to a medical problem, right? If you think in terms of our historical, legacies, the state has not really been so interventionist before the colonial period. Would you like to add a little on that? It's okay, Dr. Aday Kalam. Please keep that comment in mind. Okay, when you deepen your research further, please do think in terms of a state policy towards disease, please, right? And law, right? That's a very important connection which is not there before. Please, okay. Can we have the next set of speakers? This is MS Indu Mugi and Gayatri Devi, Tamil Nadu Law University, Tiruchirappalli, and a very interesting topic again, remnants of colonial legal responses to public health crisis, identifying symmetries and congruences. Please come forward and present your papers.
Thank you, Professor. Good afternoon, Chair and panelists. I'm Gayatri, together with my co-author Indu Mugi. Our paper is titled Remnants of Colonial Legal Responses in Modern Public Health Crisis. So in March 2020, when the COVID-19 pandemic hit India, the government announced a nationwide lockdown or the Janata curfew with stringent restrictions on movement of people, goods and services. The legislation that provided legal backing to this executive measure was the Epidemic Disease Act, which was enacted way back in 1897 to tackle the epidemic of bubonic plague, which spread in the erstwhile Bombay presidency in the 1890s. This was a one-page act with 4 sections, and it is so ambiguously and broadly worded, and gives unrestricted power and blanket protection to the central and state government officials who are acting under this act. It was also earlier criticized for its potential for abuse, and even during the colonial era, its potential for abuse was well known. For example, in 1897, the same year the law was enforced, freedom fighter Bal Gangadhar Tilak was punished with 18 months of rigorous imprisonment using this act, after his newspapers criticized imperial authorities for the handling of the plague epidemic. So next, when we come to the pandemic preparedness of our legal framework in a country, according to the World Health Organization's pandemic preparedness toolkit, areas such as quarantine, movement restriction measures, closure of public places like institutions and other such places, facilitation for availability of vaccines and drugs, and implementation of response measures need to be reinforced in a country's pandemic legal framework. However, the Epidemic Disease Act and other such acts like the Disaster Management Act, which are currently used in India or from the British era, and they are used for handling the modern pandemic outbreaks like COVID-19. And they address only quarantine and movement restriction measures, and they lack other public health related enforcement measures. The current use by the Indian government, although not colonial in nature, it suffers from a lot of vices like a lack of public health focus, and besides, it also confers broad, unregulated and unguided power to the government. Through this paper, we show that repurposing and reusing this colonial era laws to tackle modern public health exigencies like COVID-19 pandemic, only ill-suit the government's required protective measures to safeguard its citizens, and they only serve to expand the role of democratic governments by helping them consolidate and bureaucratize state power. In this paper, we first catalog the colonial responses to what is called as medical phenomenon in British India. It was largely characterized by a lack of public health focus and mainly driven by imperial interests. The government was in a reformist mode and took an authoritarian version of utilitarianism while handling public health exigencies and other medical phenomena. Theories of indigenous racial inferiority and the tropical climate of the Indian colony were mainly thought to pose public health threats to the citizens and also to the colonizers, and they were attributed as main reasons for native despotic governments. Although this discredited neo-Hippocratic approach was not used in Europe, it continued to exist in India, and it justified territorial expansions and consolidated their imperial power. Further, modern hospitals set up in cities of colonial power like Calcutta were products of Western medical import, and they created an artificial racial and class divide. They were segregated hospitals for the British and the natives, and even within the natives, there were different medical facilities given to the poor and the wealthy natives. Further, the Epidemic Disease Act fundamentally changed the relationship between the colonial state and its subjects. This was the first time the state acquired special legal and judicial powers for a purported humanitarian cause, that is to prevent the spread of the epidemic, while in reality, it specifically targeted the poor and the migrant workers. In 1895, the Pilgrim Ships Act was modified to control the movement of Hajj pilgrims from South Asia on health grounds. And it gave local authorities in India power to inspect and apprehend any passenger at any time in the name of disease prevention. Next, the Lepers Act, enacted in 1898 to handle the leprosy outbreak in what is now the modern day Odisha, established leprosy asylums and provided power to local authorities to arrest paupers and detain them in asylums. These asylums lacked efficient medical management facilities, which was brought to light by wrongful diagnosis of patients who had other diseases as leprosy, and the asylums also was also characterized by intermingling of less severe cases with advanced cases. Many fled the asylum and many died there, and people who stayed there suffered from mental distress. The colonial public health regime was also characterized by lack of systemic institutional and medical research. Medical studies suffered from lack of investments because it was not seen as a field which would further British military and economic interests. So to sum it up, it can be seen that the colonial public health measure of the British were driven by the intent to consolidate imperial state power, promote their commercial interests, and expand their political and economic hegemony in the Indian subcontinent and also elsewhere.
Hello, I'll take it from there and make two very short points. Having surveyed through the various legal responses to epidemics, one understands that laws did play a very crucial role in responding to public health crisis. But then today, as we see it, pre-independence era legislations are not automatically considered as unconstitutional unless or otherwise they are struck down by a court. So absent a legal challenge, they are still running and operating. And most of the public health legislations that we use today are still pre-independence era legislations. But their frame of operation during the colonial governance era, it was different because there was no systems of checks and balances. And the priority of the government itself was not a public health focus oriented measure. But then today, when we look at these very same legislations being used in a democratic government, they play out a little differently. Not only has India during the COVID-19 pandemic reused a colonial legislation, but it has repurposed a non-public health legislation such as the Disaster Management Act to respond to a public health crisis. Now, there's a lot of other things that we've argued in the paper, but I think I directly go to the point. Why does India have to use a highly restrictive legislation such as the Disaster Management Act? We argue that firstly, like David Arnold says, colonial medicine helped entrench colonization further in this society. And as Anandita ma'am, Professor Anandita also said, their focus was not an eradication of diseases, but rather to keep the colonial machinery either politically or economically running and operating. And today we may not argue that these reuse or repurposing these laws may help colonize society further, but they will help consolidate and bureaucratize power at the center of the government. And this could be seen, I'll take one more minute. Poorly drafted public health legislations have not only been used to swiftly respond to the crisis, but they have to be seen as part of a broader apparatus to quell dissent, to make us mandatorily install apps in an already precarious data privacy, data protection environment, and also for bringing about large scale macroeconomic changes and so discarding social security measures that were previously afforded. These kinds of changes are quite unnecessary during a pandemic, and that shows the priority of the government. So in some, we kind of end at this point where we think about why do we have to always respond to public health scenarios with restrictive frame of through a restrictive optic, and why don't we have public health legislations that ask for positive enablement of protection of public health? And we think it's because we have stuck on to colonial discourses in public health. Thank you.
This is not because other presentations were bad, but because Indumuki and Gayatri Devi have actually connected colonial history to our very distressing contemporary present. And they have, I think, dwelt upon the presence of a omniscient, which uses the gaze, the medical gaze, and the potency of legislation to establish control, not necessarily to enhance public health systems, but to actually centrally place the centralized and more and more stronger central, structure, structural coercion, coercive grip over the civil society. And you have, both of you, I think, placed the finger on the problem and the connection between the state intervention, legal intervention in the colonial period, and the parallel in a very telling dwelling, a very, very telling dwelling upon the same legislations of the colonial period being resuscitated in order to sustain this coercive centralist state power. Thank you both very much. It was a very, very timely, a very, very insightful, incisive presentation. I am deeply grateful. Thank you.
Thank you, Professor.
Professor?
Yes. Oh, sorry, because
yeah.
it was muted. So sorry. Okay. So we go over to the next set of presentation. This is by Iftam Akdam, a student in the first year, NU SRL Ranchi. His paper is also very, very interesting. Consolidation of alternative dispute resolution in the Indian legal system. So over to you, Mr. Akdam. Please make your presentation.
Good afternoon. I hope I'm audible to everyone.
Yes, you are.
So my name is Ifham Akdam. I am a student of NUSRL Ranchi. My topic is evolution of alternative dispute resolution in the Indian legal system. So mostly alternative dispute resolution is like an alternative way to go to settle disputes by means other than litigation, and it is also it is also preferred in like not only in civil disputes but and corporate methods matters as well, and also in minor criminal offenses. With the rate it is like evolving in nowadays, I thought it should be like important to know how this evolution took place at the first place. So at first I want to like inform that to state that in India we mainly follow like a 5 mechanism for ADR, that is arbitration, conciliation, mediation, negotiation, log adalat. So to understand the whole concept behind ADR, we must understand the background of this, like the historical background. So the concept of ADR is not something new in India. If we look back in time, we can see that it is something like which existed from the very ancient period. So in the Bradarneka Upanishad, we can find the mentions of kuls and shrenis, which demonstrates the presence of clans and business organizations of that time. So in there, the head of those kuls and shrenis were supposed to settle all the disputes, as in the concept of ADR, it is believed that the neutral third party should resolve the disputes. And in that time also, it was believed that the head of those kuls and shrenis is a neutral party. As for him or her, as for him, everyone is equal. So in this way, then moving to the medieval period, we had many kind of like we have many empires and rulers at that time, which everyone having their own set of rules and laws. But what was common from all of them was that every single one of them were somehow inspired by the religious texts. As we can take example of the Mughal dynasty. In the Mughal dynasty, they followed the Sali system for arbitration, which was actually inspired by the Islamic arbitration process of Turkey. Similar way, as we can see, if we look at the Bhagavad Gita, they can see Lord Krishna was acting as a neutral third party before the war to settle the dispute without causing that war. Then, like, unlike just like all other laws from the medieval period, ADR was also not very much regulated. So with the advent of the East India Company, like along with the codification and regulation of other laws, ADR also get like its codification. So its codification actually started from the year 1772, when the Bengal Regulation Act was enacted, which have certain provisions in it which were like promoting ADR mechanisms. Then in the year 1859, Code of Civil Procedure was enacted, which had certain sections related to the ADR mechanism. However, in the year 1882, the sections devoted to the arbitration in the civil code procedure was repealed, but soon in the year 1899, Indian Arbitration Act was enacted, giving India the very first separate legislation for any ADR mechanism. However, soon the Code of Civil Procedure 1859 was amended, adding section 89, which is right now the soul of the whole ADR concept. It was added by that amendment of 1908. Then in 1937, there was this Arbitration Protocol and Convention Act, which was later repealed also. So, but in 1940, Section 89 of the CPC 1908 was repealed, and the Arbitration Act of 1940 replaced the Indian Arbitration Act. So at that time, it was only the Indian Arbitration Act which we had for this whole arbitration, this whole area process. Then in 1961, India became after independence in the year 1961, India became a signatory of the New York Convention, and the Foreign Award Recognition Convention Act was established. But later in the year 1981, a case in Supreme Court was filed, namely MS Guru Nanak Foundation versus Ratan Singh and Sons. This case was on the 1961 Act of Foreign Award and Recognition Convention Act. It was the Supreme Court's decision was that the arbitration process in India is actually failing, and to cope up to that, in 1985, India signed the United Nations Convention on International Trade Law, on whose model the Arbitration and Conciliation Act of 1961 was enacted, repealing all the previous existing arbitration laws. By that time, we had, like, it is not only the arbitration, but we also had that Legal Services Authorities Act in place, but it was not completely on arbitration, on the method of, it was not completely on ADR mechanism, but it has certain provisions, just like the Industrial Disputes Act, which we had from 1947. Then in the year 2002, Section 89 of Civil Procedure Code was enacted, was reintroduced, which like is now is the soul of the whole ADR mechanism which we have in our country right now. Like all the other sections, like the Companies Act of 2015 and other act, like they have their arbitration clause only from Section 89 of the Code of Civil Procedure only. Then, like with the speed, it is like with the speed, the ADR mechanism is evolving. Like the approach is also like varying in most of the in almost every one of them. There's a different approach. Like in arbitration, there's a concept of this neutral third party whose decision is binding. However, in conciliation, it is somehow similar to the arbitration, but the decision of the conciliator is only binding when the parties accept that, and until if any of the parties do not accept the decision, then the decision cannot be binding. However, in mediation, like it is on the discretion of the parties whether they want to like obey the decision of the mediator. There is no compulsion on following the mediation results. And then there is negotiation, which is like a completely self-counseling method without any involvement from the third party to maintain the confidentiality. As we all know, there is no legal provision or statute for negotiations, so it is like not at all binding on the parties, and it is completely on the parties' discretion. And then finally, we have this lok adalat method. Like in this, it is somehow similar to a judicial proceeding, where it is decided by a sitting or retired judge, and in order to hold the authority of this court, it is given the same status as of a civil court. Then the practice of ADR is like continuously evolving, and with the space it is going on, it is actually helping the judiciary also in like it's with this overcrowding cases, as you know, like with the amount of cases which are pending in the Indian judicial system. Like if the judges in India actually work harder and like more than any other judge in any other country, still there are so dependency of cases which is actually being dealt by this ADR mechanism, as the many of the cases which could take a long time are being referred to ADR for the alternative dispute resolutions. Then, like if we come to the future of the ADR, then in my opinion, the ADR mechanism has the capability to come to the same pedestal as a judicial system. I think that it will be necessary, and soon it will be necessary to have a separate legislation for the ADR mechanism and a training program for the parties, as we have for the judges right now. Like for in the lower judiciary, the judges are first trained before like being the judges. Similarly, we need a process to have train the neutral third parties, as they're acting like a judge in those cases. So this was all, and I like to conclude it on that remark that ADR mechanism is something which is like whose future possibilities are endless, and it is not that it will be something limited to those pecuniary issues, but if properly utilized, and like there are many scopes which are untouched in the ADR mechanism. If they are soon this like explode and like research, the ADR mechanism can actually do a lot good to the Indian judiciary system. So that was all. Thank you for this opportunity and the patience listening.
Thank you, Mr. Akdam. Yes, it was, I think, a fairly visionary paper, which tried to trace out an alternative pathway to quicker justice and a quicker justice delivery system. And I would think that how shall I put this? It's a good step in the right direction, because we do have major delays in trials. There was just one thing that I was wondering, what kind of a time frame would you think that alternative dispute resolution would cater to? Much shorter, very short, would it be would it be immediate? Like, what is the kind of time frame that you were thinking of?
Like I can't state the exact time frame which would be sufficient, but I think that immediate or short time period would not be would not be enough, because we know that in every issue there are so many perspectives which need to be seen, and like giving an immediate decision will like cause some of the important issues with some of the important points will be like left untouched. So this kind of possibilities are there in immediate or like a short period of time. Then so I think that like we need a little longer time, but not like so much like the legislations which goes like the legal suits which go on for like years, like not that much, but like a period of few months should be like, I think would be an efficient, like sufficient for the area mechanism, as the main purpose of the area mechanism is actually to provide a faster but efficient result.
Okay. Are you also suggesting that mediation would satisfy both the parties? After all, there is a psychological satisfaction, right?
Yes, ma'am, there's psychological perspective to that, but I think like mediation, when it comes to like any, like not just mediation, if like whenever it comes to any of the methods, it is always that you cannot like satisfy both the parties. Like if there is a dispute, then it is necessary that one is getting like is facing some losses. So I don't think it is possible to like fully satisfy both the parties, so there will be some disparities in the end. But I think mediation can help, like it is very informal and easy to access, and so I think mediation can be a procedure which can like help the parties in like better ways if it is properly researched and advanced.
Okay. Thank you, Mr. Akdam. Now thank you very much. That was a very visionary paper, and we do need people thinking out of the box. All right, we come to the next presenter, Ishika Basi. She is a first year BA student, LLB, Symbiosis Law School, Hyderabad. The paper is Infanticide and Feticide from Ancient to Modern India. I invite Ms. Bisi to present her paper.
I'm sorry for the technical difficulty. Just give me a minute. Good afternoon, ma'am, and respected sirs. My name is Ishika Busi, and I'm from Symbiosis Law School, Hyderabad, and I really thank Telangana National University for this opportunity, and Anandita, ma'am. So my paper is about infanticide and feticide from ancient to modern India. Am I audible?
Yes, you are. Continue, please.
Okay, ma'am. So to begin with, I would like to define what is infanticide and feticide. Infanticide is basically killing of a newborn child, and feticide is killing of an unborn child. And there are numerous reasons as to why infanticide and feticide takes place. There are religious reasons, cultural reasons, financial reasons. So coming to religious reasons, and it is predominantly towards the girl child, as girl child is considered to be a bad omen in the religion, and as supported by many Vedas and Upanishads, for example, Etira Brahmana, Manusmriti, and Atharvaveda, which prefer the birth of a male child more. Coming down to cultural reasons, a girl child is always, there is a social stigma attached to the fact that the girl child is born in the house, because there is dowry, which is a culture. In fact, it's become a culture. And so the people have financial burden of a girl child being born. So they do not want a girl child to be born. The financial reason is basically because of that. And to define it, there are examples of Rajputs, the Jadedas, and the Rajkumars. The Rajputs are known to have some deviant methods of committing infanticide. For example, beheading. They consider it to be a matter of bravery. They consider it to be a matter of bravery, as it is something that's considered in their tribe. Then strangling the baby with their umbilical cord, or the fact of drowning the baby in the milk. Then coming to Jadedas, who are mainly in the regions found in the regions of Kathiawar and Kutch, they are known to poison their baby. They apply the paste of datura or mudur on the mother's breast, and the first milk that the baby drinks is known to be poisonous, or they starve their baby to death. Population control is also one of the reasons, as they, be it any kind of a tribe, they did not want the population to increase in that particular tribe, so it was not limited to a girl child or a boy child. They committed infanticide irrespective of it. Oh my God.
You are through.
Ma'am, actually my PPT is stuck. I'm facing technical
Try
issue.
using your arrow buttons rather than the mouse stick.
Yeah, I'm using the arrow. It seems to be stuck. Oh God, my screen is stuck.
Doesn't matter. If your PPT is not working, you just present what you can out of, yes, don't worry. These things happen all the time. Just carry on without the PPT.
Yes, ma'am. Just a minute. I'll just try. If it doesn't work, I'll carry on without the PPT.
Don't panic. Just relax. Just relax. And try to remember what. There you are. You've got it. Come.
Yes, ma'am. So coming to feticide, unlike infanticide, generally happens because it's generally for the unborn child, and it is definitely prohibited by a lot of ancient texts. For example, Yajurveda, Rigveda, and Upanishads, like Kaushiki Upanishad, Taitiriya Samhita, and even Kautilya's Arthashastra. So Rigveda is known to be the most oldest text. In fact, it even specifies the fact that committing feticide is equivalent to killing of a Brahmin, which is Bruna Hatya, and is equivalent to the most heinous crime possible. Then Kautilya's Arthashastra refers to 3 ways of killing the fetus, basically striking the womb, excess labor, and by the medicine. Feticide was punishable offense and was looked down upon by most of the ancient texts. Then when we look at the role of British, and when the British came to India, they find a lot of disunity amongst Indians, and they found it very different to administratively join the people together, because there were a lot of issues, for example, caste system, the Hindu social order, and given the fact that there was infanticide and feticide. So there was a lot of differences between man and women. So when they came to India, they found that this practice of infanticide and feticide was mainly prevalent in the North and the West India, mainly in the regions of Punjab and Gujarat. So when they found, in their findings, they found out that basically in the Jadeda group, the Jadeda Rajputs, that the female infanticide was committed a lot, and even feticide. So there were 400 families which did not have any female children. Then there were 15 families in the whole Jadeda Rajputs where only females were left. So they decided to ensure some laws or agreements in place to curb this practice. So they made the Rajkumars and the Jadedas sign some kind of an agreement, which they had again made from referring to the religious texts, and for example, the Rigveda and Kaushiki Upanishad. But even then, and they said that if you continue to commit infanticide and feticide, you're going to be expelled from your caste. But even then, they continue to commit it, and since they did not find any kind of change in the coming years, the statistics did not improve. So they passed a Female Infanticide Prevention Act in the year 1870. And even after passing the act, they found that there were certain gaps in the place. So they understood that the financial aspect of it was the one which was the reason for infanticide and feticide being committed. So they, in fact, they made a note of the Jadeda groups and made sure that the females would be noted down as to how many females are be born, so they could keep a track and financially help the Jadeda tribes to not commit the infanticide. But even that did not have the desired result. So coming to present times, the position of women is still considered inferior to men in terms of social status, in terms of financial aspect of it. A woman is known to be a paraya dhan, which is a Hindi term referred to the fact that she's going to get married and she's going to go away. So that was something that women are still struggling with as on date. Then as per the government census, the female population has seen some kind of an increase in the northern part, but there is still a long way to go. For example, since there has been an increase, the government issued some measures to curb this in the present day. For example, the sex determination test in the year 1977 was banned to prevent female infanticide. And in the coming years, Section 315 of the Indian Penal Code made infanticide and feticide both a punishable offense. But despite this, India still has a long way to go, because in the recent case in the year 2013, in Kanpur, there were 5 doctors who were caught conducting the sex determination test. So it still hasn't come to an end, and the measures are still being taken. Thank you.
Okay, that was a very nice, sharp paper, Ishika. Right, but I have a couple of comments. I always do. The thing is, you have to make a slightly sharper differentiation between an older, because you see your time sweep, I'm sure your research will also have these time sweeps, right? Okay. And you need to understand the position, the origin, the place of the principle which defines feticide as murder or as a sin. Because the moment you talk about a sin, it has a very important religious connotation. But at what point does sin become a crime, right? So unless you switch the definition of what is defined as a sin and what is defined as a crime, you will lose your sharpness of analysis, okay? But try to keep that in mind, okay? And
Okay,
it is, yes, personal code, personal codifications, right? The Rajputs, the Jadejas or whatever, right? Okay. And a civil society, which is looking at feticide, which is looking at, a different version of crime, right? Okay. So kindly keep these methodologies of analysis very distinct, right? Otherwise you will become scrambled. But it's a good paper. I'm not saying your paper was scrambled. I'm saying that your research should have these very clear methodological angles, okay?
Okay, ma'am.
Right, but it was a very, very sharp paper indeed. You're thinking very, very clearly, obviously. Okay, right?
Thank you, ma'am. And sorry for the disturbance in between. The PPT got
You didn't
stuck.
see me in the first session, right? So, you would have felt much better. Okay, so we will come to the next presenter, please. We do the next presenter. This is Arupa Malla and Pooja Ryan. Students, the first one is a student, first year BA LLB, Symbiosis Law School, Hyderabad. And Pooja Ryan is a research scholar, also Symbiosis Law School, Hyderabad. And their presentation is titled, A Rule Followed by the Thugs with Respect to Women and the Act That Brought Their End. Okay, so over to you, Arupa and Pooja.
I hope I'm audible.
Yes, you are.
Good afternoon, ma'am. And I would just like to take a moment, first of all, to thank TN and LU for providing us this opportunity to present our paper. Our paper is named A Rule Followed by the Thugs with Respect to Women and the Act That Brought the End. Um, First, I would like to start off with a meaning of the word thug, which currently, according to the Oxford Dictionary, means a criminal or a violent person. But it has a very historical meaning to it that traces its root back to the Hindi word thug, that means um, that colloquially has meant to cheat or to deceive somebody. And the verb of the word thagna, that is a Hindi word thagna, also means to deceive, to cheat, a swindler, somebody who steals away from other people, who cheats somebody out of their wits. But the word thug has entered the Indian history from as long as back as from the works of Ziauddin Bani, which was the earliest reference to that word. But the entire practice of thuggy is where my paper exceptionally focuses on. The practice of thuggy actually refers to highway robbers and murderers who murdered the travelers and plundered on their belongings for valuables, and they've practiced this as a vocation. They followed a peculiar way of strangling, of murdering people, and that was by strangling through a noose or by using a handkerchief or any piece of cloth. And this was a practice that was followed as a profession by the thuggies. Here I have some pictures of thuggies in act while they have been strangling, and by the virtue of it, their name also is an alternative name for them is fansigars, which literally translates to stranglers. Moving on, this menace of thuggies and the practice of thuggy was a major challenge to the law and order situation in British India while they were trying to establish their rule and uh, have a major way of it. And that is why it was a necessity at that point to focus on the eradication of the thuggy practice. And the then Governor General Lord William Bentinck took to it and made major orders to eradicate this particular process. There was the establishment of the Department of Thug Police that ran a campaign to eradicate these thuggies, to capture them, to punish them, and stop the entire association from carrying out their vocation in the first place, and distracting travelers or killing travelers on their way who were peacefully traveling from one place to another. A major name that is very prevalent in this eradication process was of Captain William Henry Sleeman. He was appointed as the superintendent of the Thug Police Department and was later on given the position of the commissioner of the same department. He has done major work and very notable work in eradicating the thuggies and eradicating the vocation of thuggies. He has ran campaigns and he has captured thuggies, which has eventually led to the disbandment of the fraternity, which was declared by himself by the year 1839. Although there were occasional mentions of murders in the same manner as a thuggy would do, but by the year 1839, mostly this area of this fraternity of thuggies was dysfunctional by the virtue of the work that was done by Captain William Henry Sleeman. He has also worked extensively in this manner and published books, namely Ramsiana, which was the vocabulary of this peculiar language by thugs. there was a report on depredations committed by thug gangs of Upper and Central India, and thugs or fansigars of India. These were the three works that our paper has majorly depended upon. And these were the works directly from the pen of William Henry Sleeman. These acts were a series of acts that were introduced from the year 1836 until 1848 that essentially led to the suppression of the thugs, and eventually the dysfunctioning of this association of the fraternity. The thugs essentially have one major rule that they follow, and they believe that the violation of this particular rule actually led to their disbandment or dysfunctioning. And these were rules regarding women, regarding children, and regarding people who were disabled. But to understand these rules, first we have to learn the origin of the thugs, which they trace back to the very popular folklore of the battle between goddess Kali and Raktabija Dana, where goddess Kali, while slicing off the head of Raktabija Dana, the demon, spill the blood drops, those were spilled on the floor. New bodies of the demons sprang up, and so goddess Kali gave rise to, or created, two men from the beads of sweat on her arm, and gave them a piece of her cloth, which and instructed them to get rid of these demons by strangling them and without spilling a single drop of their blood. And these are the men who the thugs trace their origin to, uh, um, and believe that, and for the same reason believe that goddess Kali is their tutelary deity, and they pray and worship goddess Kali for the same reason. The thugs were definitely a superstitious people, and therefore, which I earlier mentioned, that they believed that their end came just because they did not adhere to certain rules and regulations. These rules were, first of all, one major rule was they would not leave out any single person from a group of victims that they have. And they would strategically find out a group of travelers where they could murder all of them and plunder their belongings, so that they could take back the loot home. And for that order, they made sure that they did not include the group of travelers that they victimized, did not include any workmen, any smiths, any men grazing cows or goats, any person who's disabled, who has lost sight or who has lost a limb because of a mutilation. Neither would include any women or children. However, there have been mentions of the murder of women, where one particular instance that comes to my mind that has been mentioned in Thugs or Fansigars of India by William Henry Sleeman is of Kali Bibi, who was traveling from Maharashtra to Hyderabad, and she was murdered on her way because she was carrying valuables that could profit the thugs if she was killed and if she was plundered. And thus, such murders and such further murders led to the eventual dysfunctioning of the family that carried out the murder of a woman, that violated the rule of murdering of women. This is the reason why they believe that their eventual collapse happened. However, the British feel that the eventual collapse was because of the campaigns that they ran and because of the acts that were passed in the name of Thuggy and the Coity Suppression Acts. That would be all from my side. Thank you.
Thank you very much, Arupa and Pooja. A couple of comments before we move on to the last presenter. I would like you to think about, a possibility that a new way of, the confessions, to their utterances that are being recorded by the larger, recording, processes put in place by the British government. And what you find here in this scenario may be, a kind of retrospective understanding of an explanation for their ultimate disbandment. Okay, why I'm saying is, you know. In a previous presentation, I think it was uh, on the alternative dispute resolution. The moment you use visuals, right? Okay, you are using a very different medium, and in alternative dispute resolution for ancient India, it was a colonial print. All right, and even your visuals, right, which you are referring to, are all from a colonial representation. Right now, some of you have done your MAs and MPhils, right, in the School of Social Sciences, Hyderabad, and representation is a very important coloring, right, of how voices are recorded and what they're made to say, and what they are actually also being made to think, right? Okay, before the colonial process, the colonial recording process, put these voices together, you do not have a voice of the Thuggis caught literally on record, right? Okay, so it might be a very useful exercise to think about your sources, right? Or how much are these sources suggesting a colonial a colonial coloring, right, over these so-called authentic voices of the Thuggi, right? So do think about it, right? Radhika Singha, Despotism of Law, is a very important book for you to go. Okay, that was a very, very insightful presentation. Obviously, you are going the right way, but a lot more is required, right, in order to make your critical location very obvious to the reader. Okay, so now we go over to the last presenter, Ms. Rashmi Banerjee, also a student, MPhil, JNU, and her topic is To Serve the End of Justice, Debates on the Jury System, Colonial Bengal. Over to you, Rashmi.
Hello, everyone. I hope I'm audible. My paper deals with the official and public debates around the criminal jury system in the late 19th century Bengal. As we know, the civil jury system had already come to an end in India by the 1830s, so it will just talk about the criminal part of it. Now, in the 1800s, India saw a raging debate. In legal history, we would always come across this debate among official circles as well as in public sphere around the issue of judicial independence through the separation of judicial and executive offices. My paper seeks to analyze the role of the jury debate within this broader question. Now, to give some context, the jury system was introduced in the company courts of Calcutta, Madras, and Bombay by the early 19th century, but it was the Criminal Procedure Code of 1861 that standardized the jury system at an all-India scale. However, provincial governments, by the same CRPC code, retained the power to determine the types of cases and the territorial extent that would involve jurors, thereby subjecting the system to executive discretion. This reflected an undercurrent of official apprehension regarding the efficacy of the jury system. The unease among the executive officials stemmed from their distrust for the image of what they call the duplicitous native, as well as the lack of educated Indians to serve as jurors. Despite administrative doubts, the jury system was heavily endorsed by the vernacular press. In fact, continuous demands for the expansion of the system in Bengali press led the provincial government to seek reports from Calcutta High Court judges as well as subordinate judges and magistrates and sessions judges on the desirability of expanding the system of trial by jury. The High Court judges backed the operation of the jury system in this report, but suggested that the government should extend the area radius from which jurors could be drawn to improve the quality of jurors and also to reduce the number of jury members in a particular trial from 7 to 5. These reports were seen as moderately encouraging of the jury system, therefore keeping them in place, but also led to its expansion in other districts. But the proposals of reducing the number of jurors in a single trial and increasing the area radius from which jurors could be selected were dismissed. Now, this search for respectable jurors, if we look into this state machinery trying to look for respectable jurors, we can find out some interesting points. Now, according to the Criminal Procedure Code of 1861, I quote, any male person between the ages of 21 and 60 who is not the subject of any foreign state and who resides or personally works for gain within the local limits of the High Court within its ordinary original criminal jurisdiction shall be qualified and liable, end quote, to serve as a juror. But we know that on ground, finding qualified, what they called qualified jurors remained a perpetual concern, as sessions judges argued that laxity on the part of jurors to convict accused persons, especially in murder trials, was a sign of them being unskilled in handling facts and evidence. What is noticeable is that even though the search for respectable jurors continued to dominate official discussions, there was no stipulated criteria for expectability in any court. But most often it was associated with financial status. In fact, in 1882, the eligibility criteria was revised such that only people with an annual income of 100 rupees or more or net assets of at least 3,000 rupees could serve as jurors. All persons who held any office at the High Court were disqualified from the service, in addition to a long list of government servants who were exempted from jury duty. A later report confirmed that an overwhelming number of jurors in Bengal were landholders, followed by bankers, merchants, and tradesmen, school teachers, and college lecturers. Also in the list were government servants not associated with the judiciary, servants in private companies, and municipal and district officials. The concern regarding the jury system within the executive in Bengal ultimately led Charles Eliot, the conservative lieutenant governor of Bengal, to justify its curtailment in 1892. He issued a notification to this effect, restricting the system both in terms of its territorial extent and the types of trials to which it was applied. Now, the notification of the Bengal government, dated 20th October 1892, received a massive backlash from the press in both India and England. This compelled the British Parliament to constitute a commission under H.T. Prinsep, a puisne judge, a permanent judge of the Calcutta High Court, to look into the jury system in Bengal. The commission report showed a great support for the jury system. In fact, the two Indian judges who were the sole two Indian members of the commission even proposed an extension of the system in districts where it was not already operational, given its advantages in encouraging legal education among Indian public, which was a very frequent argument which was brought forward in support of the jury system. The report was widely discussed on public platforms, which successfully strengthened the demand for the withdrawal of the jury notification, restricted the system. As the notification was rolled back, most vernacular newspapers in Bengal and beyond celebrated the move. Following this watershed moment in 1892 and 93, the jury system operated steadily in Bengal for the next 3 decades, and it was only in the 1930s that some judges of the Calcutta High Court permitted the partial withdrawal of the system from parts of Dhaka as riots cases came, and there were apprehensions that communal juries would often be biased in such riots cases. This, however, does not indicate a smooth functioning of the system. Henceforth, the popularity of the jury system among High Court judges was not reflected at the district level. And in fact, sessions courts and magisterial courts often had problems with jurors. They were fraught with discords between judges and jurors, and newspapers frequently carried reports of judges forcing jurors into agreeing with their judgments in trials. Whenever, and we can find several reports in the native newspapers, reports of the National Archives, attesting to such discord. Whenever jurors gave dissenting verdicts, judges used coercive means such as imposing fines to sway their opinions. Therefore, with the executive and subordinate judiciary staunchly pegged against them, the jury system owes its prolonged survival to a favorable public opinion reflected through a steady backing from the press. Besides, the judges at the higher level judiciary continually fought back against executive fiats that attempted to restrict its functioning. Naturally, the provincial government could not make significant changes without coming under heavy public scrutiny. This paper, I argue that on a wider scale, the jury system also became a platform for contestation surrounding judicial autonomy, while the executive was wary of unpredictability in trials involving jury, High Court judges enthusiastically supported it and often advocated for its expansion. One can argue that such support stemmed from the fact that unlike judges who were required to adhere to impersonal bureaucratic rules, jurors' judgments could more openly endorse moral codes of contemporary society and stood starkly independent of executive control. Thus, jurors became an avenue for the judiciary to establish its agency beyond executive dictates. Thank you. That was my paper.
Thank you very much,
Yeah.
Rashmi. That was again a very, very sharp paper. Also, I would like to add a couple of pointers. First, you do have in the 1930s and in the 1890s, Bengali jurists, judges, lawyers, all holding out for the jury system because they looked at an educational role for the jury system to play. And this also has, I think, a very strong commentary on the making of the legal subject, right? Because it was seen as a big lacunae, a big lack in the ordinary, even educated Bhadralok class about the orientation of the subject, right? There was another presentation which used the word citizen very likely, but I think the word citizen is actually a far, far later interpolation of public discourse on subjecthood and citizenship. Radhika Singha herself uses a subject/citizen, right, for the 1930s, 1940s also. So I suggest that you do keep this component of the understanding of a legal subject who is constructed, who is actually trained to be one. Training is part of the jury system, right? So it is educational, very definitely, for the jurists who are already in position within the British legal system. There was also, well, yes, roughly this. Do try to look at the use of, the notion of the jury in literature, and try to extend. It's your MPhil, I understand, but if you want to take it up for a later heavier research project, I suggest you also look at the jury system across the British Indian territories, right? That would actually give you a sense of what this legal education for a civil society pertains to. Thank you very much, Rashmi. Very politic, very good paper, very sharp. Okay, thank you.
Professor, that brings to the end of the presentations. Would you like to add some feedback to the presenters, Professor?
Sorry, I didn't feedback to the presenters. I think you mean to say on a larger
Yes, Professor. You are muted. I just was wondering what had happened.
Oh, for Rashmi. For Rashmi.
No. That brings us to the end of presentations, isn't it, Professor?
Right. Oh, so sorry. Yes. Yeah. Sorry. Yeah. So thank you very much, presenters. I thank our Vice Chancellor for giving me this proud privilege of hearing so many wonderful, very well researched papers, all of which added new dimensions to our understanding. I also understand, from all your presentations, that a lot of work and a lot of thought have gone behind, your papers. Please remember that legal history, as all of you have delved into it, is a very, is a very important domain of research. Unfortunately, as our respected Vice Chancellor, Professor Elizabeth, has already remarked, it has actually not been very popular as a research area. So please do understand that our present predicament of understanding a well-educated civil society comes with important relocation within a legal culture and history of law, and more research on these historical connections to our present location within the rule of law, within a constitutional, constitutional grammar, a new language of citizenship is very important. In fact, it is central to the way we understand our location in the present Indian nation state. We have heard fantastic papers. I thank all the presenters. I thank the organizers. I thank especially the Vice Chancellor for having given me this opportunity for not just hearing so many wonderful papers, but also to interact and to talk to all of you, with whatever little inputs I could give. Thank you very much. I'm deeply grateful for this opportunity once again.
Thank you so much, Professor, for steering the session in such a way that it was a fruitful experience for all of us. And thank you all the delegates who are present and who shared all of your research with us. It was a quite knowledgeable and enlightening session. I thank all of the delegates for being present and participating. Further, I would like to thank all of the observers in form of our own faculties and students from the university. I thank you all for being here. Hope you all had a wonderful, fruitful time all the way through. Have a good evening. We will meet you back in the next session. Thank you. Take care. Thank you once again, Professor.